which supports statistics refer to in respect of the propensity of poor persons to flee when released on bail, I submit the Honourable Court is evenly expected to apply the principle of the wealthy having the necessary means to travel, relocate, and thereby fleeing the country by the state. Our Constitution, the presumption of innocence, preservation of dignity, and numerous other provisions reserving the rights to accused persons, does not envisage nor provides for the paralysis of the Constitution at the hands of the state where bail proceedings are concerned. Mere submissions that a poor person, even a homeless person, will flee if released on bail is abhorrent in our constitutional democracy. Something more substantial needs to be in evidence other than a submission that there is a suspicion. Umlazi falls within the region of this Honourable Court and is a stone throw away. In the event of this matter being transferred to Regional Court or High Court, it will in all likeliness be within the building of this Honourable Court and thus remain within the jurisdiction of this Court. I therefore reside within the jurisdiction of this Honourable Court. As a person of meagre means, I cannot afford to lose bail money, even if the amount is slight. My bail amounts were in the amount of 5,000 Rand each for my 2 pending cases. I can afford to pay bail with financial assistance of my mother and extended family, but most certainly cannot afford to lose the bail money. I have no travel documents, neither the means to travel outside the Republic. It is serious charges, admittedly so, but I am standing before court as an innocent man until such time I am convicted and a first offender. The punishment I could face is a lengthy period of imprisonment if convicted, but the length of imprisonment is not enough for me to attempt to flee and so implicate myself in an incident. I intend to plead not guilty when the matter reaches trial stage. The prospects of a conviction is further to be considered with reference to the strength of the state's case. Should the state's case be submitted to be fragile, the sentence or sentences are not a given but rather a remote possibility. I am therefore not putting the cart before the horse, contemplating conviction and setting my mind on a course that will prejudice me greatly in future. My pending cases are cited below, and so too the circumstances surrounding my arrest for this matter. Pending case 1, Becky Temba, SAPS case 138-423, possession of prohibited firearm, a pistol and ammunition. The matter is now in regional court and almost ready to be set down for trial. I was due to appear in Umlazi Court for court whilst on bail for this matter, Umlazi C, court case number C74223, on 13 October 2023. I had very recently been released on bail for this matter during September 2023. The Durban High Court order was granted 28 September 2023 under case number D 9885-2023. I am the only accused in this matter, and the next court date for this matter is March 2024. Pending case 2, labeled SAPS case 26542. The charges are for murder, conspiracy to murder, and various other charges. I was arrested under the last court after my matter was adjourned to a future date, as my attorney and I walked out of court for the pending case herein. Labeled SAPS case 26542. During this application, it was brought to the Honourable Magistrates' attention that the High Court granted me bail with full knowledge of this matter that I was alleged to be implicated in, as appears from the record, the affidavit of the investigating officer Padbu. I was granted bail in the amount of 5,000 Rand. The next court date for this matter is 12 April 2024 in Durban District Court 10. I advised my attorney at Umlazi Court that I was advised by the SAPS prior to my appearance, whilst on bail, that I will be rearrested under Umlazi at my next appearance for another matter. This, SAPS will dispute and have disputed, but I submit it is the truth, and nonetheless arrived at court prepared to be arrested. Despite the content of the affidavit of Padbu at Annexure A, for the purposes of the record, Your Worship, there is one annexure to this affidavit, Annexure A, that will be the matter in Umlazi Court that was transferred to Umlazi Regional Court sitting at Chatsworth, Your Worship. That will be the charge sheet, the affidavits of my client, Padbu, and the record of proceedings, Your Worship, the bail proceedings. Despite the content of the affidavit of Padbu at Annexure A here too, citing no less than 6 serious cases, this specific case included, that I am allegedly linked to, the High Court having granted me bail with full knowledge thereof, I did not flee whilst out on bail for the Umlazi matter. I returned to court on the next court date and was arrested after the adjournment. Bail was granted on the 28th of September 2023 and I was arrested at Umlazi Court on the 13th of October 2023. Pending case 3, Ria Saps case 323, I am still appearing in Durban District Court 11 for this matter and the bail application is part of both. I am one of 4 accused in this matter. Our next appearance to continue this bail application is set down for 18 March 2024. The current matter, I was in custody on the US Saturday to await the finalisation of my bail application when I was charged with the matter before this honourable court. I do not have a valid passport. I submit I do not have any intention to travel outside the country and further have no family or otherwise ties to anyone outside of the country. If the court grants me bail, I will return to court in every court day prior to my trial. I will further return to court to stand trial. I will comply with any conditions that honourable court may impose on any that is granted, such as signing a substation meaning periodically, which is easily enforceable. I submit the numerous possible future cases for which I may be charged in future listed in Annexure 8 of the Tibz Case 138/14 did not prompt me to flee, as I duly attended the last court trials on that. The latter supports my submission that I am not righteous. Section 6011. I am not familiar with the evidence that will be brought against me in this matter, nor am I aware of the whereabouts of any physical evidence against me. I am therefore not in a position to conceal what is saying. I further submit that given the event of me becoming aware of the whereabouts of the evidence that I shall not conceal what is saying. The latter evenly applies to any other pending matters against me. The evidence appears to be cellular phones and firearms in possession of the SAPS. It is therefore submitted that the evidence is in possession of the SAPS in a safe place and ostensibly only witness statements could be outstanding in this matter, with the exception of phone reports of documented evidence and perhaps police reports. I am not aware of the identity of any of the state witnesses in this matter, and pending matters, but undertake not to intimidate or influence witnesses if I were to be advised of saying, so jeopardizing my prospects at trial. Any such acts would most certainly reflect negatively on me speaking to guilt rather than innocence. I would not sabotage justice in such a manner at any time. The evidence is in safe custody of the SAPS members and is not capable of being accessed by me. Concealment or destruction of same is therefore not possible. I have no relationship with the state witnesses, and if there are witnesses outside SAPS members, I do not know their identity. I have no knowledge as to who the witnesses may be and do not intend to find out who they are. My interest is in my freedom, preparation for my pending trials, and maximizing the time by procuring employment to support myself and my children once on bail. My interest most certainly does not lie in making plans to harass, intimidate, or interfere with witnesses, try and locate evidence which is already under lock and key at SAPS, so prejudicing myself before any of the matters come to trial, performing acts that will speak to guilt rather than innocence. Section 6011D. I did not provide false information to the SAPS at the time of my arrest and have not done so in respect of any other pending matter. I am not on parole, having no prior convictions. I further did not fail to comply with any bail conditions whilst on bail for the Mlazi matter. It might be submitted that SAPS members tried to find me at my home to arrest me on another matter, and I was not at home. They only found my uninhabitable room with a few clothing items. This does not imply that I was on the run or fleeing. This had been submitted in my prior bail application for the matter in DC 10 Durban in opposition to bail, implying I contravened the High Court order not resigning at my homestead. I submit I resided at my designated homestead throughout. That is where I suspect SAPS informed my family that they wished to arrest me. Had I been on the run, I would most certainly not have gone to Mlazi Court on the next court date, knowing that I would be arrested. I was simply not home when SAPS went to my home. Subsection 6011. I submit that the release of my bail would not result in public disorder, shock, and outrage. Should the Honourable Court, as in the should the Honourable Court experience an increase of members in the public interest in my release for this case, it should not reflect this outrage. In any event, public outrage should not be inferred from media interest and an increase of members of public in the gathering. I submit that the public outrage referred to speaks of public as a whole of the Republic and not a few interested parties. Public peace, order, and security will not be disturbed or undermined. I submit that the interest in this matter lies in the status of the deceased persons as celebrities, and not in myself, nor me possibly being released on bail. There have been no protest or banners at court during my first 2 appearances calling for refusal of bail. My life will not be in danger if I were released on bail. The onus lies on the state to show that exceptional circumstances exist showing that my life will be in danger. I submit that no exceptional circumstances exist. The Honourable Court requested that I and my co-accused reveal our faces in full sight of the media and public gallery during our first appearance after after the state confirmed unequivocally that our lives would not be in danger should our identities be released, neither would it affect identification by state witnesses, as the state does not intend to conduct an identification parade at any time. Subsection 11A, exceptional circumstances. I am not aware of the content of the opposing affidavit of the investigating officer or officers in this matter, and am further unable to anticipate what the submissions, whether on affidavit or orally, of the investigating officer will be. As it is my application, I commence somewhat blindly as to the state's case against me in opposition to bail. I can therefore only speak to the strength of the state's case in a limited manner, but submit that I will be able to show the above honourable court that the state's case is artificially bolstered for the purposes of bail with multiple charges. The strength or fragility of the state's case will be evident after evidence of the state's case through its witnesses, and I humbly request that the honourable court considers my attorney's submissions during her address on the state's case if it should become clear by the time of her address that the state's case is in fact somewhat fragile. I have not had sight of the contents of the criminal docket and related evidence against me, and am therefore electing to decline to refer or comment on the allegations against me, bar for denying that I committed the offences set out in the annexures and intend pleading not guilty at trial. There are, however, circumstances information that will be revealed during this bail application through the state's evidence, my co-accused evidence, and cross-examination of the state witnesses, if any, my affidavit and my attorney's address or closing argument, that will show the above honourable court whether the state's case is capable of being addressed in respect of the strength or weakness, and should be taken as exceptional circumstances in the event of fragility being apparent. I submit that the exceptionality of the circumstances is that I did not attempt to flee whilst out on bail for the Umlazi matter. I had personal knowledge that I would be arrested after my court appearance there, but still attended court. Surely something more substantial should be before court to convince the court that I will flee should I be granted bail. The fact that both the High Court and myself were aware that this case and several others were possible pending cases against me at the time of me being granted bail in the High Court, Annex A, shows that the High Court clearly deemed my release on bail just by having granted me bail. This alone speaks to exceptional circumstances. I submit that the High Court order is being undermined with the state's opposition to bail in this matter in an effort to keep me in custody. This pending case was within the High Court's knowledge at the time of me being granted bail, and so too within the knowledge of the state, service of process on the state. It is evident that the state did not deem it necessary to oppose bail on appeal, with further submissions on pending cases cited in Padwa's affidavit at the time of the appeal having been considered. If this was indeed a consideration, it did not weigh in favour of opposition, implying that bail is in essence not opposed in totality to the existing application and cited pending matters. The intention of the order of the High Court was not to leave a door open for arrests on all other cited cases. If this were so, bail would not have been granted on appeal. Continued arrests are anticipated to be piecemeal, the first having been effected on the 13th of October, for which matter I was granted bail in Durban DC 10, on the same grounds as set out herein in respect of my release on bail by the High Court. I am aware that my release on bail stands on two legs. The services of justice permitting my release on bail, and thereafter to show that exceptional circumstances permit my release on bail. It may be said that my personal circumstances alone do not amount to the exceptional circumstances, but I submit that exceptionality of the circumstances can be revealed during the state's evidence and during address. The existence of exceptional circumstances does not have to be revealed during the applicant's case in its affidavit alone. Evidence before court remains evidence, even if it were placed before court during the state's case and challenged during address. In this regard, I submit that my evidence in my affidavit is capable of being challenged by the state after having heard my application, but that I am not given the opportunity to challenge the state's evidence if theirs is given by way of affidavit. The only manner in which the state's evidence is capable of being challenged, if by way of affidavit, is by challenging same during address. If oral evidence is given by the state, my attorney will challenge same during cross-examination. I therefore ask that the Honourable Court take into account my attorney's submissions and during cross-examination, if any, when considering my release on bail. This is dependent on the Honourable Court permitting supplementary answering affidavits from the applicants. That would be answering affidavits to the state's affidavit, Your Worship. Counts 1 to 12, the counts enumerated requires some discussion herein. The applicants are charged with all counts. Count 1 is conspiracy to commit murder in respect of Kiernan Forbes. Counts 2 and 3 refers to the murder of Kiernan Forbes and Tebela Motswane. It is submitted that a conviction on murder and conspiracy to murder would be an error on the part of the trial court, as proven facts that speak to conspiracy to murder could only result in a conviction of murder, not both. Reference is made to Ngogo versus S, 852-202, 2021, ZA SCA 166, 3 December 2021, that has reference herein. Conspiracy is not capable of being proved solely on telephone calls made and received near the area in which the incident occurred. More will be required by the state from the defense at trial. In Mbanyaro and another versus SA 271 2007 2008, ZAWCHC 45 2009 1, SICR 631C, on 11 August 2008, Judge Musa delivered judgment on 11 August 2008 in which he held as follows. In my view, the mere presence and running away from a scene of a crime with the perpetrator do not meet the requisites of common purpose. The trial court held that the presence of the second appellant on the facts of this case go beyond mere presence and in itself constitutes an act or acts of association that are sufficient to satisfy the requirements for the establishment of common purpose. I cannot agree. In my opinion, that finding is clearly wrong and a misdirection, that it stretches the doctrine of common purpose beyond reasonable and legitimate boundaries. The elements of the offences in all counts include intention. In respect of intention or dolus, the element stands to be proved by the state at trial, and Masingili and others versus SA 44812 2013 ZAWCHC 59, 2013 2 SICR 67, WCC on 20 March 2013, the court held as follows. It is incumbent upon the state to prove the perpetration of aggravating circumstances as defined in Section 1(1)(b) of the CPA during the first stage of the trial culminating in the verdict. This was in fact a manner in which the case was approached in the regional court. The appellants were charged with the offence of robbery with aggravating circumstances, and they were convicted as charged. The convictions were thus based on a finding that the aggravating circumstances have been proved beyond a reasonable doubt. The doctrine of common purpose would, however, not have assisted in proving any dolus on the part of the first and second appellants. It is settled in law that this doctrine can only be invoked for the purposes of proof of causation as one of the elements of a crime. It cannot serve to impute the dolus of one person to another. CS versus Malenga 1963 1 SA 692A 694F to H. We are accordingly of the opinion that the inclusion of the phrase or an accomplice in the definition of aggravating circumstances in Section 1(1)(b) of the CPA Criminal Procedure Act is inconsistent with the Constitution and therefore invalid. In keeping with the court's reasoning in Masingili above, the state will have its work cut out to transfer intention to all accused in this matter for each count. Causation refers to both factual and legal causation. Although Masingili deals with aggravating circumstances as the element of robbery, it is submitted that the court's view on transferring dolus with the proof of common purpose and thus conspiracy evenly applies to this matter and its accused. A wrongful act that was a causa sine qua non of the loss or damage does not necessarily result in legal liability. The sine qua non maxim is expressed as the but-for test. But for the action of this applicant would the results have ensued. The state cannot submit with confidence to this honourable court that causation will be proved, both factual and legal causation, and further, that intention in the form of dolus eventualis, directors or indirectors, that's intention, will be proved in respect of all counts for all accused. Counts 4 and 5 refer to unlawful possession of a semi-automatic 9mm pistol and 6 rounds of ammunition. It is unclear whether there is more than one pistol with reference to the charge sheet and annexures provided to my attorney. I submit that the state intends to proceed on joint possession, which is addressed hereunder. With reference to the discussion on intention, transferring intention to a co-perpetrator and causation, one has to look at counts 6 to 10, which is attempted murder. The state would presumably wish to proceed with dolus eventualis on attempted murder charges. I submit that proving same will be an onerous task for the state. In highlighting the charges individually, the Honourable Court is asked to consider that the multiple of charges during my bail application is simply to bolster the state's opposition to me being granted bail. It is unlikely that joint possession will sustain counts 4 and 5 during trial, and further that intention would be a prickly pear to address where transfer of intention is concerned, and further to prove intention in respect of attempted murder of bystanders, which is account 6 to 10. An identity parade has not been held in terms of the rules set out in the Criminal Procedure Act to date hereof, it is apparent that the identification of all accused in this matter stands to be tested at trial. Positive identification in terms of the rules is not before court to confirm the strength of the State's case. The State clearly stated that it does not intend to hold the identity parade. The identities of all 5 applicants and the outstanding accused 6 and 7 in demande ×2 have been revealed in the media and exploded on all screens on television and social media. Speculations run high, but it must be considered that doc identification will carry no weight at trial, as the accused have been presented as the 7 accused implicated already through the media. The CCTV footage of the incident has been available on social media since the day of the incident. The person appearing to be pointing what appears to be a firearm at Mr. Forbes is clearly masked and small or short in stature, as speculation grows as to whether the alleged gunman is indeed a small female. I am by no means a short person. The footage may not bring the State's case against me further at trial. The firearms in count 4 appear to be undisclosed amount of firearms. The make, model and caliber is unknown at the time of this application. The charge is not one that can be answered in this form and stands to be amended. Unless the State amends same, it stands to be quashed on application after receipt of the further particulars. I am expected to answer to charges during preparation of my bail application before this Honourable Court. Reference is made in plural to firearms. More particularity on this will be requested from the State. In the absence of the following, I submit that the counts with reference to the charges against me will not necessarily amount to conviction. Should all of the below be provided by the State to court during my bail application and to the trial court, the State stands on a stronger footing, failing which the State's case remains weak. That there were bullets recovered and removed from the deceased. The bullets were properly transported, secured, chain, and identified as belonging to the spent casings found on the scene, and further identified as having been fired from one or more of the firearms seized. Fingerprints lifted from the spent casings and firearms matched my prints, showing that I was in physical possession at the time of the alleged possession. If so proved, can it be linked to the time and period of the offence? Recent possession or possession thereof on one occasion cannot serve an artificially created presumption that possession was indeed at the time of the incident, linking all acts to myself and my co-accused. Your Worship, if I may please request a body break. I think it's the heat. The perspiration is absolutely pouring down. Just 5 minutes just to rinse my face, Your Worship. I would appreciate that.
Okay. 5 minutes, you say?
Thank you, Worship. I'm indebted to the court.
Court will adjourn for 5 minutes.
Myself, the new mask of refillable fragrance. You've seen them all.
Fix it together. Yeah, go to a